the certification indicating that the MBR for the 2013 fiscal year had been satisfied, as there was a funding shortfalls and concerns about payments to various creditors. And we believe, in light of those concerns and the significant concerns in the current fiscal year, it would be appropriate to open an inquiry, to initiate a complaint against the Winchester Board of Education and to follow the 10-4B procedures to ensure that the MBR is satisfied for the 2012-2013 fiscal year and the current year as well. And so that's what we'd be asking for in the resolution, is for the State Board to initiate a complaint against the Winchester Board of Education with regard to the MBR. And other parties, just for your information, other parties can be added thereafter if it's found that there are other governmental bodies that are responsible for the failure to implement the educational interests of the state.
Just to ask the obvious question, since it's obvious that the problem here is not the Winchester Board of Education, but the town of Winchester, why aren't we adding them as a party from the get-go?
We think that it's the way that the laws are set up, the statutes and the regulations. Excuse me. It would be most appropriate to initiate the complaint against the board and then add the town at a later time. So there's question whether it would be legally appropriate to initiate the complaint against the town in the first instance.
So what happens? We appoint a hearing officer gets appointed? No, in this?
It would be an investigation. That would be
okay. There'll be an investigation by our department.
Yep.
And that investigation will then come back to us and say, "Hey, guess what?"
Well, I think we have to wait and see what happens.
Come on.
We think we know what's going on, but I think it would be best to let the process play out and see what the investigation turns up. And it may well be that we have to add other parties to the complaint at a later date.
Okay. There is some point at which it's said that even judges are allowed to, know what they know as people, and this seems to be one of them. But so the process would then be you'd have an investigation. Then if you conclude, the investigation concludes that it's time to add the town of Winchester, then come back to us, presumably several days before our next meeting or whenever you come back to us, and ask for a resolution adding them, or is that only after?
It's not clear that a resolution would be required at that point. That's something... If that is necessary, we would consider at that time. But so it probably would be appropriate to do a resolution to add the town, or any other party that is deemed responsible.
I think while the words of the last public speaker are still echoing in this room, we should hang on to those echoes about the rights of children while we unravel this problem that adults have created in Winchester.
And with that being said, how long are we talking about? Because it sounds as though, at least it's been alleged that bills aren't being paid and programs are maybe closed as a result of the fiscal condition. Is this going to be done on an expedited basis? And if so, what are we talking about in terms of time?
Well, the regulations allow for, so the respondent would be given an opportunity to respond to the complaint. A complaint would be issued. The respondent would have, the Winchester Board of Education in this case, would have an opportunity to respond, and then we would have 20 days from the date of the receipt of that response that the investigation would have to be concluded, and that's what the regulations allow for. I would just say, as a general matter, with these types of investigations in general, we just don't know what it's going to turn up. And so it would be, obviously, we can make every effort to do it on an expedited basis, but to promise that, we can complete the investigation, for example, in, just a handful of days, I think would be not prudent.
Just to follow up, I mean, this board had to address a situation in Stamford, I believe it was, and there was a long period of time that had lapsed before it was brought to the board. And I would prefer not to see that happen if, in fact, we can avoid it or avert it in some way.
On those same lines, I have all the respect for the process, and I understand that has to be done. But my concern is the gentleman that spoke in the public sector section. He said there's still $400,000 left that's unpaid, and that the district is going to be out of money in December of this year. So it's almost like we're just waiting to be hit between the eyes with the problem. I mean, the process can proceed, but the fact of the matter is that that district is out of money. And going back to what Terry said, the children and the kids, they didn't do anything wrong. And so, and probably some of these people that aren't going to be paid in December may be some of the people that are still part of the $400,000 that's left out there, and they may stop providing services in the end of this month. So we can go through the process, but what's Plan B? I mean, they're out of money. And I'm not suggesting that we all open up our wallets and give them $300, but are we talking to OPM? What are we doing to salvage this school year? Because I'm looking at through the tunnel, and there's a light, and it's a freight train. And I don't see that this process is going to resolve anything other than to say, guess what? We're going to be out of money in December, and we still have $400,000 worth of bills. So what are we going to do about that?
Thank you, Chairman Taylor. We have been in conversation with OPM about this for about 3 weeks now. The town has gone to the Municipal Finance Advisory Committee, which is a function of OPM, to talk about their financial distress. Secretary Barnes gave them very specific guidance, one of which was that they needed to go back and actually assess its supplemental tax to their local townspeople. Now, based on the comment that I just heard this morning, that doesn't sound like the case. I think that at this point, what we were seeking from the board was the ability to start action from the department's perspective, so that we can not only continue that coordination with OPM and with the governor's office, but that we can also get on the ground in the district to see what the financial problems are, what, if anything, can be done to ameliorate them while decisions are made. And we've also been asked by both the town manager, and I think there was a shared letter from the head of the Gilbert School about advancing the ECS dollars. Statutorily, right now, our first read is that we don't have the ability to do that. And if we were going to take a step like that, obviously it would just be an interim stopgap measure. But it will take people well beyond this body in terms of the General Assembly, the governor's office, the state treasurer and stuff to be involved in this. So I think that our hope is that we were responding to the desperate need that was brought to our attention, and that by getting in there and getting on the ground, we can get more information so that we continue that coordination, and then people outside of the board actually start taking measures to address what's going on the fiscal side of the town. So, yes, we were very well aware that we were asking for the investigation to start with the board versus including the town in the initial investigation. That was actually some guidance that we received from the Attorney General's office, who we did check with before undertaking this, to get us in the door, to start helping the community, to start seeing what's really going on, and what does it mean to the vendors of Winchester, the Gilbert School, shared services for special ed, those types of items. So at this point, we would like to have the opportunity to go in there and start helping them. And yes, this plan will be much larger than what we will come up with here.
I think the only thing I disagree with is I believe that while we're doing this against the Winchester Board of Education, like the chairman alluded to, this is bigger. I believe the town of Winchester should be in it right from the get-go. We don't have time. This is the 1st of October. We meet in 60 days for December when they run out of money. These should be up front. The town of Winchester should be involved in this proposal that we're going to vote on today, and we should hold them accountable, because why are we holding a BOE accountable when they're not the fiduciary of the funds to begin with? And if there's illegal activity, I'm curious to know if a town official made illegal activity, what's covered under the bond that goes back to the town? I didn't see any of that in the report either. So when I look at this, I am disappointed that I do not see the town of Winchester and the Winchester Board of Education. And I believe they should be involved in the get-go, because this is a serious problem.
Let me go ahead and respond. Sharing these sentiments, as expressed by several board members, may I ask Mr. Van Horst and Ms. Dempsey, the reason why we are proceeding in this sequence is based upon legal advice that we have received and our own considered judgment regarding the way in which 10.4b itself must unfold. Is that accurate?
Yep.
Okay, so it's not because it's a wish one way or the other. It's purely a function of the 10.4b statute and process. However, what you've heard from Kathy, and I want to underscore it, is that we have not been waiting for the 10.4b process to, outside of the scope of the formal investigation, work directly with OPM and through them, but also directly with the town and the district to establish what's occurring and to see whether there are remedies available. The 10.4b process, for good or for ill, as pertains to any given matter, is it's a laborious one. It requires an investigation first. It requires a sequence of steps. That's important from the perspective of ensuring thoroughness and that we get to the bottom of an issue. It isn't the only path to a solution. So we did think that it was prudent to initiate this process today, which was the soonest possible available State Board of Education meeting. So it was an available outlet, but rest assured that Ms. Dempsey in particular will continue her efforts under these very complex circumstances.
Mr. Chairman, a question for you and the Commissioner. If at some point when they initiate this 10.4b and they feel now it's time to bring in the town of Winchester, do we have to convene, or can they immediately, give the investigation the flexibility of adding any additional party as they deem necessary to be a part of this 10.4b?
Yeah, that depends obviously on the wording of the statute and the regulations. The footnote in our report says that a local government body may be added upon a finding by the State Board of Education. If that's the case, then obviously it will have to come back to us. It can come back to us at a special meeting. It can come back to us at a special meeting that is held over the telephone so that we don't have a problem getting people together. As I understood Mr. Van Horst's statement of the timeline under the statute, yeah, the complaint, we initiate the complaint today. That's what today's vote is. The local Board of Education against whom the complaint is directed has some number of days to answer, and the investigation, the report has to be completed within 20 days after the answer. Now, I'm just guessing, but since the local Board of Education's chief executive and agent is who initiated the complaint by sending the letter, that the local Board of Education's response to the complaint will be fairly rapid and will say, yes, of course, there is a problem here, at which point the 20 days will start running. We may be able to move more quickly than that on the next step, if the next step is warranted, and add the local government. Yeah, ultimately, this is one of those problems where somebody walked off with a lot of money. There may be ways to recover that money against various actors. I certainly don't want to start opining on any of that. But if the local government doesn't have the money, then becomes that's why OPM is necessarily deeply involved in this. We can issue an order, but you can issue an order to a dry well telling it to produce water, and you don't get much. Maybe you go, if a special tax is an option, but the local government doesn't want to do that, that presumably is something that can be enforced by a court, not directly by an order from us. But all of that has to play out. But I do think that it's clear. The reason this is on the agenda today, instead of having been postponed despite how late it came to us, is because the urgency of it was obvious, and the ripple effect that it could have. It's not just the town of Winchester schools, it's the Gilbert School, it's the services center. It just ripples out and affects hundreds or thousands of kids. So it will move, it's got to move as fast as it can, but it's got to follow whatever the statute and regulations say, too.
My only other concern, Mr. Chairman, Mr. Commissioner, ECS funding has always been a hot topic with the municipalities, where some of the ECS money has actually gone into general funds and for operations of governments. If we allow this ECS payment to go early, does it give other what is the trickle effect down on the backside? I have grave concerns in the way ECS money has been funded, because, again, a fiduciary of education really is not the Board of Education. They propose a budget. It's up to the municipal government to adapt it. And if we've had issues, historical issues with ECS money being played with, as we should say, then what's going to happen in the future if we allow them to get an ECS payment? Do we get a game where a municipality says, oh, we'll run out of money, give me my ECS money early? That is a serious major concern.
Point well taken, Mr. Jaskowitz, and it's obvious, but it's worthy of saying out loud. Faster payments of ECS money doesn't result in an increase in the ECS dollar amount. So the problem will remain unsolved unless we understand the multiple dimensions of it and what is going to be done to fill the gap. Nothing is off the table, but also we are examining our statutory authority for any kind of early payment, and we are very mindful of the point that you just made, Charlie, which is that it sets a precedent. So thank you for making that point.
And it's not just the early payment that sets a precedent, but in a time when the municipality is obviously under fiscal stress, to say the least, it may be that if it takes special authorization to make an early payment, that early payment doesn't go through the legislatively prescribed route of funding to the schools through the local municipality. There is some precedent in the statutes for exerting more control, as you know, for instance, on the extra money that went to alliance districts. There was a control on how that was spent. It wasn't at the choice of the municipality. So there's a lot to be worked on this, obviously, both as matters of policy and finding out what the facts are, which is what this will at least get started. Andrea?
Thank you, Mr. Chair. And recognizing that we're a few layers removed from this in some sense, but also being very mindful and in agreement with Gwen's comments, which were echoed by Terry, do we have a sense of the vendors' willingness to be patient through this process? Just because I'd hate to turn on the TV and find out the kids are not being picked up for school, or, the Wheeler Clinic is not providing services to students with special needs.
At the moment, the vendors have continued to engage with Winchester to provide services. The shared services, who provides the special education services, actually right now has estimated that their costs for the year would be about $800,000. So I mean, they are still yet in, providing those services, even though they know that that's an outstanding issue. The same thing with the Gilbert School. But again, at some point, if we're going to stop payment or continue, or not we, if Winchester's going to stop payment, or if, in the case of the Gilbert School, they're only going to be able to pay them a fraction of what they actually owe, then at some point I think that they would alert the town that services would cease, or at what time frame the services would cease. But right now, no, it's my understanding that they are still providing those services.
Thank you. Oh, okay, we'll go back to 6B, which is approval of the staffing flexibility agreement. I don't think we moved that. May I have a motion? Mr. Jaskowitz, second. Okay. Mr. Jones. Morgan, I guess we'll let you or the commissioner, whichever your wishes, run the show.
Mr. Morgan Barth is the Division Director for Turnaround. Morgan, would you please introduce the item?
Honorable Chairman, Madam Co-Chair, board members, good morning. It is my pleasure to present for your consideration the staffing flexibility agreement for Elm City Montessori School located in New Haven. You will recall that the State Board of Education granted approval of a local charter in July 15, 2013. The school is on track to open in fall 2014. Since July, the founding team of Elm City Montessori has been engaged in conversations with New Haven Public Schools and the New Haven Federation of Teachers about appropriate work rules for the school. Today, I am pleased to announce that the New Haven and the NHFT have mutually agreed on a staffing flexibility agreement for Elm City Montessori. In your original board packet, you had a version of that flexibility agreement, and in your supplemental folder, you have a slightly revised copy. The final agreement contains 4 changes, which I will outline briefly, and then I will introduce Dave Lowe and Eliza Hawley, who will speak briefly to the rationale for the flexibility agreement. So if you find the agreement in your supplemental packet, the 4 changes are that on page 2, section D1, the phrase "as directed by the administration" has been struck from the sentence that now reads that staff will participate in arrival and dismissal duties, including meeting buses or parent-guardian vehicles in the morning and ensuring that all students have been safely dismissed at the end of the day, inclusive of the 7.5-hour workday. The second change is on page 3, section D11. The phrase "participate in leadership opportunities as directed by the administration" was struck. I'm sorry.
The entire D11 was struck?
Yes, I suppose so. That was D11. It now ends at D10. Thank you for that clarification. On page 3, section G1, which speaks to the professional learning and development, G1 now reads that the certified staff of Elm City Montessori School will participate in up to 1 hour of daily collaboration period to be scheduled during the certified staff school day, 4 hours per week, and 1 day per week of unencumbered prep time. And the addition was that additional responsibilities to be completed at a per diem hourly rate.
That's a different section 4H.
I'm sorry, that's section 4H. That I brought you guys. Section 4H, number 4, has added the phrase "additional responsibilities to be completed at the per diem hourly rate." Compensated at the per diem hourly rate. So I wanted to alert you to those 4 edits. The substance of the staffing flexibility agreement has not changed. So the reason that we are here bringing this to you is according to Section